So, just as a way of understanding, is there anyone here among you three jurors that believe that drug usage by either parent at any time, in any place, whether the children are around or not, uh, is automatic? You don't need to hear anything else. Clear. You won't need to hear anything else. It will be clear and convincing evidence to you that drug usage alone is enough to terminate the parental rights of either of my clients.
No.
No.
Anybody believe that? Okay. Is there any threshold, Miss Walker, that you would say a type of drug that you would hear of would make you automatically believe that there's nothing else that you needed to hear, that the rights need to be terminated?
No.
Okay.
No.
Okay. What about a amount of usage? Would that change your answer?
Really, what would change my answer is how it's impacting their ability to take care of the kids.
Oh, I love that answer. I'm glad that you are
That's
you.
yeah.
Okay.
Yeah, that's going to be very instrumental. And also, did they give the kids any? And were they careless with leaving paraphernalia access? To me, it's like, you have a gun in your house and we have the right to bear arms. But, are you putting your kids in a situation where they can get access to it and then have a issue with you know um changing their lives or someone else's life because they have gotten access to this gun? So I'm treating the drugs in the same capacity, because you can have a problem, and I'm assuming you're talking about illegal drugs and not legal drugs. People have addiction problems with medications that they're getting from their physicians. So you know
Or
Totally.
even to your point, alcohol use, Mr. Blackman. Alcohol is a legal drug,
It is.
and so too is caffeine, and so too is nicotine. Okay, so I'm
Right.
glad that you guys are, you know, so Mr. Blackman,
So this show
um,
should be renamed Drugs and Politics, is what I'm hearing.
right. So I guess I just want to make sure that we're on the same page here, because we're trying to make sure that you will be able to listen to what the law is and apply the standards in a fair and in a fair way, and instead of just making up your mind that, hey, I don't like the fact that their parenting style differs from mine, so I'm gonna terminate. Mr. Blackman, how do you feel about the state, like the government, in other words the police arm of the government, coming in and seizing, taking your son from you when he's 10 years old?
I would have some problems with that personally because I'm not abusing drugs and neglecting my child. So for me personally, that would be a major problem. But if I was to examine a case where somebody had been a drug abuser, or even just a frequent user, I mean, abuse and use is a fine line, I think. And it also depends on the severity of the drug. I mean, we touched the easy ones, alcohol and nicotine and perhaps caffeine and those things. But ultimately, there's a spectrum of drugs. So what type of drug are they using? Because some states marijuana is legal and other states it's not. So it's a smorgasbord of various narcotics that can be utilized for people for various means, and so I'd have to evaluate the evidence of what the narcotic is, what the frequency of the use is. Was it being done in the presence of the child? Was it being done at the or allowing the child to even imbibe it? I mean, I hear cases sometimes where kids have cocaine in their system, or they have other drugs in their system because they found their parents' drugs lying around. Those would be major factors for me, for sure. But the drug use itself, I'm a little more open to hear more evidence on that.
Good. And that's, sir, I agree with you. And my take here is, and what I'm hoping to find out if you guys agree, is that, remember, CPS needs to be involved only if there is abuse or neglect, not if they just disagree with your parenting style.
Right.
I like
Okay.
I want my child to have dreadlocks at 10. And if the state doesn't like that, the state should not be able to come and take my child from me. Uh,
I agree.
but, Mr. Morgan, um, can you tell me what types of, or what type of information, what does clear and convincing mean to you when you hear those terms together relating to either drug use or domestic violence? Clear, what kind of evidence would you think you would need to see that would be considered by you to be clear and convincing proof of some abuse or neglect?
I think that's going to very much depend upon the context. That would be, and I would also be in the midst of my colleagues here or my fellow jurors looking at this. So this is it's very speculative question to answer. But Mr. Dunlop, I wanted to ask you, you just said CPS should be involved in abuse or neglect, but I thought that Ms. Moncrieffe said that it had to be imminent danger. So I'm just wondering, with regard to CPS's involvement, is it imminent danger, and is it short imminent danger, is it long-term imminent danger, abuse and neglect? I mean, if you can for a moment neglect something and that becomes the basis for termination of parental rights. I'm a little bit concerned right now, or confused, I should say. So when you're asking me about clear and convincing, I could very easily say, well, yes, that person neglected that child at that moment, but that doesn't necessarily mean that that was imminent danger, and it doesn't necessarily mean that it was abuse. So I need a little bit of clarification on what we're looking for right now.
Thank you. And I will have to yield the floor, but just a quick answer is that the jury charge, if you end up being on the jury charge will have definitions in there to help you know that information.
Great. Thank you so much.
Mm-hmm.
All right. At this point, I wanted to instruct the jury of Nearman that the judge will give you instructions and definitions on the burden of proof and on clear and convincing evidence. And you will be required to follow the law on that point. Thank you all very much for your attentiveness and for answering the questions of these lawyers at this time.